Hello everybody, I'm Brian Tuck. Welcome back to Tuck's Rules. Today we're going to talk about employment agreements and restrictive covenants. Not sure what those are? That's okay, we'll get into it. Ready? Let's go. For employers, the employment contracts that the sales force and key employees are subject to is a great tool to protect the company's trade secrets, customer lists, prospects, and any pricing formulas that they may have. Generally, you hear people refer to these agreements as non-competes, being very general. Now, a restrictive covenant, if it's well drafted, actually includes three major components. The first of which is a covenant that the employee will not compete against the company after termination. Usually this is coupled with a geographic restriction within 10 to 50 miles surrounding the company, depending on what the company's market is, and a time restriction anywhere from 2 to 3 years following termination, all the way up to 5 years on the long side. That's the first thing. That's the non-compete part of it. The second part of it is a non-solicitation clause. And what that says is that the employee, after separating from the company, will not attempt to solicit any prospects or any customers of the company for their own purposes. The third major component of a well-drafted restrictive covenant is a covenant not to solicit the company's employees. In other words, not to try to pull a Jerry Maguire, leave the company and attempt to hire away the company's employees to start a competitive business. So well-drafted restrictive covenants actually have three components to them, not just the non-compete provision. Now, from an employer's perspective, how do we make these things enforceable? Well, that's actually very simple. The easiest and most inexpensive way for the company to make a restrictive covenant enforceable against an employee is to present the employee with that employment contract at the time of hire. Just like every other contract, there has to be consideration provided to the employee in order to make it enforceable, so the company can offer employment at the beginning of the relationship. And Pennsylvania and New Jersey courts have held that that is sufficient consideration to make the restrictive covenant enforceable. Now, sometimes companies want to add a restrictive covenant to an employee's deal in midstream, meaning after the employee has already been hired. If that's the case, the employer must offer some signing bonus, some additional consideration, perhaps additional weeks of vacation, comp time, or other benefits that the employee did not have to begin with in order to render the restrictive covenant enforceable. If you have any questions about this, please feel free to contact me. You can reach me on Twitter, on Instagram, through Facebook, or certainly through the website at tucklaw.com. I hope this video was helpful, and I'll talk to you soon. If you're interested in building your business from square one to viability, check out my first book, Risk, Create, Change, a Survival Guide for Startups and Creators, which is now available on Kindle and in paperback on Amazon.com.